Good afternoon, Senators. This afternoon, we're going to do a clause-by-clause consideration of Bill S-7, an act to amend the Immigration and Refugee Protection Act, the Civil Marriage Act, and the Criminal Code, and to make consequential amendments to other acts. I'm the Deputy Chair, Senator Ataulajan, and I would like the committee members to introduce themselves, starting with my colleague on the left.
Art Eggleton, Senator from Toronto.
Mubina Jaffa, Senator from British Columbia.
Elizabeth Hughley, Senator from PEI.
Senator Ngo from Ontario.
Senator Andrew Chuck, Saskatchewan.
Scott Tanis from Alberta.
Nancy Ruth from Toronto.
From Toronto.
Thank you. So is it agreed that the committee proceed to clause-by-clause consideration of Bill S-7?
Yeah, Madam Chair. Madam Chair,
Yes.
before you do that, I have a question I'd like to ask of officials. This results from a brief that we've received overnight from UNICEF Canada, and it raises a certain issue I want to clarify with officials dealing with criminalization matters. So I assume it would be justice officials if they're in the room.
Yeah.
They have a right to be here.
Well,
And they don't have to identify.
I believe it was sent around. I have it in any event. But I have a question.
Ask the justice officials to complete it.
Okay. So I guess we have the justice officials here, and they can answer the question.
Okay.
Why is we in camera?
Are we aren't in camera?
No, this is not in camera.
Senator, the rules require the clause by clause be done in public.
Okay. UNICEF is saying in their document they've submitted to us that they are concerned about children's increased potential for criminal liability as a result of the proposed changes to the Criminal Code and the Youth Criminal Justice Act. Children are the intended subjects of protection of Bill S-7, and there is, I'm reading from their document, and there is no compelling reason to justify increasing criminal sanctions against them in the context of protection from forced marriage. So they go on to recommend, well, it says, let me read it further. Should a child be implicated as a potential victim or as a facilitator in a possible situation of forced marriage, alternative interventions should be pursued, such as special program of prevention and child and family counseling under the auspices of child welfare authorities or community-based organizations with appropriate competencies. Now, the recommendation says, we recommend that children and young people be exempt from the measures set out in the proposed new sections 293.1 and 293.2 to the Criminal Code and the proposed amendments to subsection 14, subsection 2 to the Youth Criminal Justice Act. Could you comment on that, please?
Thank you, Your Honor. The provisions in the code generally will apply to all persons on Canadian soil as a basic principle. However, as you know, criminal liability only begins generally as of the age of 12, and between the ages of 12 and 18, the procedure and the sentencing regime is governed by the Youth Criminal Justice Act. So they are already subject to a separate regime that takes into account their lowered degree of moral blameworthiness and their age and development. And generally as well, in terms of the provisions of criminalization, these two provisions of active participation in a forced or early marriage ceremony require specific intent and active participation, and the Crown prosecutor and would normally only use their discretion to prosecute those that are the most responsible for a particular act. When youth are involved, there are separate measures which would apply if ever they are specifically charged with an offense. And normally, since these provisions are, as you did mention, Honourable Senator, there for the purpose of protecting vulnerable persons, it is unlikely that they would be used against such vulnerable persons generally. It's not the intent.
Unlikely and not the intent, but that still means it's quite possible that there could be criminal charges laid against a 13-year-old, a 14-year-old, may come under the Youth Criminal Justice Act, but still there could be charges against such a person who may be, as the term forced marriage indicates, forced into a marriage, may participate in a marriage, but may not be properly protected by these provisions if in fact they're going to be charged.
Yeah. I think it's, I mean, there are many offenses in the criminal code that are aimed at protecting individuals from harm, but that are drafted in such a way as to capture the victim. Okay, so a good example would be the offense of incest. So the offense of incest says that any person who has sexual relations with their parent, their child, their sibling, and so on and so forth. Now, you can have a situation where a parent and a child are engaged in an incestuous relationship. The Crown will exercise its discretion not to prosecute the child. So I don't think there's really any reasonable fear that Crown prosecutors will lay charges against the victim of a forced marriage or the victim of an underage marriage. The offenses are there in order for charges to be able to be laid against the people forcing the person to marry, or the people who are celebrating and assisting a marriage where a person under the age of 16, is being married. It's just not. I don't think anyone will exercise their discretion to invoke the criminal process against the person who is very clearly seen as the victim of these offenses. And that is not to say that these individuals can't have siblings who are under the age of 18 who are actively trying to influence the person to be an underage bride or an unwilling bride. And that's exactly why the offense is drafted the way it is, so that where there is a sibling who may still be under the age of 18, but who is participating with their parents in bringing an unwilling sister, for instance, to the wedding, to say that that child ought not to, in any circumstances, be prosecuted, I think would fail to create the mechanism to protect the victim. So the offenses are there. The victim of the offenses is not going to be charged. And I think we as with all other offenses, we simply have to have some amount of confidence in police and prosecutors to be able to distinguish the victim from the perpetrators.
Okay, thank you.
Thank you. So is it agreed that the committee proceed to clause-by-clause consideration of Bill S7? Agreed or not? Agreed. Shall the title stand postponed? Shall clause 1, which contains the short title, stand postponed?
Agreed.
Shall clause 2 carry? Shall clause 3 carry?
On division.
Shall clause 4 carry?
On division.
We were given,
I had amendments to this bill on age and also on provocation, but since we are going to be doing it on, and my colleagues, the rest of the senators have those amendments, what I would like to do is that on minimum age, page 2, clause 2.2.
no, just point of order, didn't we just agree to accept clause 4?
Yes, we did.
And no, it was on division, but I said we didn't agree on it. Was on division.
But once you say on division, you have voted.
But I didn't
So
hear. I was
that's why I
vocal.
want to clarify.
Yeah.
Then we have to determine whether we will go back.
Someone didn't give her a chance to talk.
Yeah.
No, I asked if shall clause 4.
I understand what you asked, but you rushed through, Senator.
Okay, it's,
With respect.
What I would like to get on the record, if I may, with everyone's permission, is I would like the age of 16 to be age of 18.
No, but are you we've got to do it according to the rules here. Are we now saying that we will revert back?
Maybe revert back.
And not vote on clause 4, that will, the understanding is that we have not taken a vote on that? Or are we retracting that vote? We need to clarify that. And then, no, we can't do that.
No, we can't start again.
Then secondly, if you're proposing it, then perhaps you could propose your amendment on clause 4 so that we stay within the rules of the Senate.
I was proposing it.
So I think what we'll do is we will revert back.
Okay.
Revert back on this? Is
On
there
clause
agreement
4.
to do so?
Clause
Let's
4.
not get over it.
Okay. No, I think it's important. It was raised in a committee by the opposition that when you're in the chair, you should follow the rules. And I think that's the strength of the Senate when we do that. It is not to thwart any intentions. It is to ensure that we can withstand scrutiny publicly.
So since we have reverted, may I please say, I would like to amend 2.2 from age 16 to 18.
Shall the amendment...
Would you speak to your reason?
Yes, I certainly can speak to my reasoning. As I said in second reading, and as I asked the officials, that Sweden, Switzerland, Germany, and Pakistan have the age of 18 as the national age of marriage. Why are we having it a lower standard at the age of 16? It is shown that 16 is a very young age, and since we are looking at protection of women, I believe that age 18 is the appropriate age.
Yes.
I don't agree with this amendment, and I do want to speak to it. 16 was chosen, as I recall from the testimony, and justice people are here, because of the fact that there is a provincial marriage responsibility for administering marriages, etc. And we do have not the same kind of systems as Sweden, etc. For the ones that you pointed out, there are infinitely numbers of others that have chosen their own age. So I think it is for Canada to choose its date and to justify it, and they have chosen 16 in consultation with the provinces. So it seems to me that it would be an unnecessary interference by myself. You may disagree with me. And we did that, I recall, a number of times in our debates on Young Offenders Act, what was the appropriate age. Varying provinces had different, and we had to come to some consensus, and we did that. I remember a bill to do with young people joining the forces. It was adamantly argued that they could go into the armed forces at a lower age than 18, and that it was in their best interest to do so. So I think I would, on this section, I have no qualms to leave it as it is, and with respect, would not support the amendment.
Senator Nancy Ruth.
And my understanding of the provincial age of marriage is that it rotates around 18 or 19, but there is a provision that allows for marriage earlier, I think, to the age of 16 in certain circumstances under certain conditions. So I would not be opposed to raising this to 18, leaving some kind of special conditions at the minister's approval for age 16. But our norm here in Canada is 18 or 19, not younger. The rest is separate.
Senator Eccleston.
Well, I could only echo Senator Nancy Ruth's comments. Provincial authorization for age of marriage is around 18 or 19. Why shouldn't the Canadian government be more in accordance with the provinces and territories that make up the country? So I will be supporting the amendment.
Question. Shall the amendment carry?
Yes.
Yes, agreed.
All those in favor? All those against? You got them? So the amendment is declared defeated. So shall clause 4 carry?
On division.
Okay.
As we go.
Yeah. So we're still on clause 4, Senator Nancy Ruth, and we'll wait till you're ready.
No, I'm okay.
Shall clause 5 carry?
On division.
Senator Schaffer has an amendment.
No, it's the same, and it will
Okay.
be the same argument on all my amendments on ages. I will not argue at this place.
So shall clause 5 carry?
On division.
On division.
Shall clause 6 carry?
On
On
division.
division.
Agree. Shall clause 7 carry?
Madam Chair, I would like to move to delete this clause, as I believe that this completely changes the definition of provocation, and provocation is well covered in the criminal code, and I believe that it is not necessary in this bill, and this bill is not the right place to bring the issue of provocation, so I ask that this clause be deleted.
You're going to speak, or okay.
If a senator is opposed to an entire clause, I would remind that in committee, the proper process is not to move a motion to delete the entire clause, but rather to vote against the clause standing as part of the bill. On this matter, I prefer Senators to Boucher citation 6986, which notes that an amendment to delete a clause is not in order, as the proper course is to vote against the clause standing part of the bill. Similarly, O'Brien and Bosch.
It's okay, I accept that, and on division.
Well, can I speak on the matter as well? What precipitated this provocation coming into this, and particularly viewing the fact that it comes from a Minister of Citizenship and Immigration, is relevant to the issue of honor killings. Now, honor killing isn't specifically mentioned in the bill, but it was part of what was stated by the Minister and what has been stated time and time again. And yet, as the Minister had to admit under questioning, there is no successful case in this country of honor killing being used as a provocation. And heaven forbid that it ever would be. It's a terrible thing. And provocation, no, and what you're changing here changes it in other circumstances, which may work against women in many different cases. Some women are provoked, as men are sometimes provoked. And the courts have to make those kind of decisions on an individual basis. And I put my trust in the courts to do that, as opposed to making this change in this terminology in the law, which I don't think serves well the justice system in this country. And to bring it in under the possible, somewhere down the line, honor killing may get a bigger position in a court case, I think is no evidence base at all for that. There has not been one successful case of somebody being able to argue on the basis of honor killing. So I think it's appropriate to remove the clause and let the provocation provisions of the criminal code stand as they are.
Senator Eaton.
Can you clarify, your two lawyers, in provocation, isn't it here that the person, as long as they're not doing anything illegal, cannot be construed as provocation?
Well, yes, I think there is that sub-context of it, but I think the system as it is now works well. It takes into consideration the individual cases in a court hearing where provocation is used and can be then used to reduce the sentence from perhaps murder to manslaughter.
Okay, but Senator Eglin, explain this to me. So if my husband beats me up, that's illegal, isn't it? That's assault. Or if I assault him and he kills me, then he'd still be able to use that as provocation because I did assault him. I did do something illegal, right?
It's only if it's a five-year sentence or more.
Offense.
Indictable offense of
Not
5
otherwise.
years or more.
That's what
That's the
changed.
provision in here.
Thank you.
So there are other cases where that provision would eliminate them.
Senator Jaffer.
The concern, as we know that Mr. Spratt, who is very knowledgeable, a lawyer from Ottawa, who is very knowledgeable, said is that we are really limiting the definition of provocation. In fact, we are changing the definition. And as Senator Eaton rightly asked, is that, what we are saying is that the victim has to have committed an offense which is punishable by 5 years. Completely changes the definition of provocation. And Senator Eggleton talked about honor killings. What really disturbs me is that in the public presentations that the Minister of Immigration has made, he has often quoted the Sophia case. And as we all know, the Sophia case was a case of a terrible case. None of us are accepting of what happened in those circumstances. But in that case, the accused didn't even raise the defense of provocation, because to raise the defense of provocation, first you have to admit you were at the scene and you did kill the person, but you're saying that you killed that person because of provocation. The Sophia case didn't even raise that. So my concern is that the minister himself is confused as to what is provocation. And I caution all of you colleagues that I think it's a mistake to change the definition of provocation in the code.
Thank you, Senator Jaffer. Shall clause 7
Can we
carry?
have a show of hands on this one?
Yeah, I was just going to ask the question that whether shall the clause carry.
Okay.
Should we have those in support of the amendment?
You have to
You
read
go
that.
through it, okay.
The Honourable, and the question would be on shall clause 7 carry. Senator Atulajan.
No. Oh,
Yeah.
yes. Yes, sorry.
Senator Andrzejczyk.
Yes.
The Honourable Senator Eaton.
Yes.
The Honourable Senator Eggleton, PC.
No.
The Honourable Senator Hubley.
No.
The Honourable Senator Jaffer.
No.
The Honourable Senator Nancy Ruth.
No.
The Honourable Senator No.
Yes.
The Honourable Senator Tanis.
Yes. I should say the other one.
Yeas
Oh, no, you're
pour
supposed to say no.
5, 5. Nays contre 4, 4. Abstentions, abstentions, nil, aucun.
5-4 again.
Okay, 7 carries.
Clause 7 carried. Shall clause 8 carry? Shall clause 9 carry?
On division.
Just waiting for Senator Nancy to. You okay, Nancy? Yeah. Shall clause 10 carry?
On division.
Agreed.
Shall clause 11 carry?
On division.
Shall clause 12 carry?
On division.
Division.
Shall clause 13 carry?
On division.
Division.
Shall clause 14 carry?
On division.
Shall clause 15 carry?
On division.
Shall clause 16 carry?
On division.
Shall clause 1, which contains the short title, carry?
Speak to that.
Yes, Senator.
I think this has had an enormous amount of attention from the witnesses that appeared before this committee, and regardless of the position that many organizations have taken on other aspects of the bill, I think they virtually all said that they thought this was very inappropriate terminology for a piece of legislation. Zero Tolerance for Barbaric Cultural Practices Act. And I don't think we should adopt this particular title. I think it reflects badly on ethnic community organizations in this country. Why else would you have the word cultural in there? Barbaric cultural practices, and I think we've heard from a number of organizations that feel that while they may understand there's an attempt here to relate it to violent actions against women and children, that nevertheless it casts a wider net in terms of the communities in our country, and suggesting that some of them might have barbaric cultural practices. I don't think communities by and large do. Some individuals, some families do, and I don't think that it is fair to put that kind of a label on this bill. The overall organizations have indicated much difficulty with this thing in terms of its supposed protection of women and girls, and some of the organizations that deal with services to these people, for example, and have said that they don't think this bill is meritorious at all, and particularly they note that this title. There's a written submission that came from the Barbara Schleifer commemorative clinic, in which they say they assist over 4,000 women every year through our legal, counseling, and interpreter services. They say Bill 7, introduced by the Government of Canada November 5, 2014, if passed, will result in increased criminalization and deportation of certain racialized communities in Canada, and will re-victimize women and children who are survivors of violence. As an organization that has worked for nearly 30 years exclusively with women survivors of violence, we are particularly concerned that the proposed changes will create further institutional barriers for already marginalized communities to report violence and receive support. So I think the title, not to mention the rest of the bill, which I've indicated I'm opposed to with the words on division, but in this particular case, I think this committee should decide to remove this short title. It serves no useful purpose. The main title itself covers it's an act to amend the Immigration Refugee Protection Act, the Civil Marriages Act, and the Criminal Code, and to make consequential amendments to other acts. That's an appropriate title, because that's exactly what this bill does. The short title, I think, is not something we should be adopting, and so I'd like a recorded vote on that.
These people wanted to speak. Yeah, I have a list, Senator Jaffer. So, Senator Ruth.
I was very struck by Avi Go's comments when she was here yesterday, Monday, that just putting these words into the short title gave the framework for which the whole bill was understood. I was very struck by that, but I've also been struck over the last few years, maybe 4 years, by use of the government in using words that are perhaps inflammatory, one might describe them. You see them here and there, and I think it's hugely a mistake. I think it is changing the English language. You hear it picked up in the media, and I'm absolutely opposed to this. If Canada was a country that did not have barbaric practices, such as solitary confinement in prison for over half a year for people, and that we use solitary confinement regularly for punishment rather than protection, I might feel differently. But there are lots of barbaric practices in this country, and we'd better not call the kettle other than what we are.
Senator Jaffer.
I would like to remind the committee that many, except for 2 witnesses, all witnesses, even people like Megan Walker who were in support of this bill, said it was a mistake to have the short title of Zero Tolerance to Culturally Barbaric Practices. We also heard from witnesses who said that children will not report their parents if they are perceived to be barbaric. Senators, I believe that this is a huge mistake to have this title stand. In our country, I've always been very proud to be part of this country because I have felt that we are an inclusive country. But when we start calling some people in our country as barbaric, culturally barbaric, we are starting an us and them society. It's the wrong step to take, and I urge you to think very carefully before you support this title.
Senator Tanis.
Thank you. There can be no doubt that the word barbaric has made us all uncomfortable, and I think that in many ways this is an uncomfortable subject that requires us to be uncomfortable, and I'm impressed with the amount of dialogue that's gone on about this. I think it has raised this issue to a level that it would not have been raised in the public and with other constituencies had we not done this. I would say that the one witness that we had, who in fact was a victim of forced marriage, agreed with the title, barbaric, and I was persuaded by her testimony. I think that also the minister quite rightly spoke about not just immigrant cultures, but other cultures within our country that seem to think that this practice is acceptable. And the message must be sent to everyone that this is indeed not acceptable conduct in civilized Canada. So I will support it.
Senator Hughley.
Thank you very much, Madam Chair. I would like to certainly support the comments of my colleagues who feel very strongly that the word barbaric and the word culture should never come one after the other. I think especially in our Canadian laws, they are reflective of our Canadian peoples, and I think it's an inflammatory word that is very basically an inflammatory word which we must be very careful of using, because in fact there are terminologies that we do use. Violence to me is just as disagreeable as barbaric, but I think violence is what it is, and I think that our legislation should reflect that. So my concern is not only for. It's fine to suggest that culture is we all have a culture, but do we associate it with our cultures, or do we automatically associate it with a specific culture or specific cultures? And that not only affects those people who might be immigrating, it affects people from those countries, but it also, more importantly, I think affects our neighbors and friends. That I feel that the terminology is just not appropriate for our Canadian legislation. Thank you.
Senator Jaffer.
No, if the word was on its own is barbaric, I would still be uncomfortable, but I could understand that we were trying to send a message. But when we use culturally barbaric, it's very clear who is it is pointed at, which communities it is pointed at. And I believe, as I already have said, we are dividing communities. We are sending a very strong message of us and them when we include culturally barbaric. And I think, I truly believe that the Senate of Canada should not be accepting such a title.
Senator Eaton.
There's no doubt there's been a lot of controversy surrounding barbaric and culture together. But I think it'll be much easier for people coming to this country, or for Bountiful itself, which is very much part of this country, to understand that there are certain practices, mostly aimed against women, young, forced marriage, genital mutilation, which is not in this bill, which has already been covered, polygamy, are simply not acceptable practices. And I would like to think that most people who want to come to Canada for opportunity and freedom to grow and live as they want will accept that our values do not tolerate those practices.
Senator Andrewchuk.
I want to support what Senator Tanis has said, but add to it the barbaric practices that this bill is pointed towards, and I agree with the bill, so we're really talking about the title now. So I accept the bill. I think it's necessary, and I support it. As you know, I've raised the issue because it has been in the public domain, perhaps brought up by the opposition, members not here at this table or maybe not even in this chamber, that there are different interpretations of what this might mean or could mean. But the minister was very clear that it was the barbaric practice within a culture that probably is not accepted by that culture itself. So that was one point that I recall. The other is that we're not talking about barbaric practices just coming into this country. We have them within this country, and we should be doing everything we can to stop those practices. I respect that the government has to bring in legislation. We're here to critique it, and I accepted the minister's interpretation and his intention and the government's intention of how they interpret this phrase. And it was, with due respect, not the way that I've heard it at this table in opposition to the title. So I'm inclined to accept it at this point. I think the debate has been important. This bill was introduced in the Senate. There will be time for further reflection. There will be community input. And I think, as Senator Tanis said, I think we have done a service to highlight what I think are inappropriate practices and that we should be very strongly against them.
Shall Clause 1 carry?
The Honourable Senator Atulijan.
Yes.
The Honourable Senator Andrewchuk. The Honourable Senator Eaton.
Yes.
The Honourable Senator Eggleton, PC.
No.
The Honourable Senator Hubley.
No.
The Honourable Senator Jaffer.
No.
The Honourable Senator Nancy Ruth.
No.
The Honourable Senator No.
Yes.
The Honourable Senator Tanis.
Yes.
Yeas pour 5, 5. Nays contre 4, 4. Abstentions, abstentions, nil, aucun. Clause 1 carries.
Clause 1 carried. Shall the title carry? Shall the bill carry?
On division.
We want a roll.
Roll call? Yeah, let's have a roll call. On the
The bill carry. Shall the bill carry?
Shall the bill carry. The Honourable Senator Atulijan.
Yes.
The Honourable Senator Andrewchuk. The Honourable Senator Eaton.
Yes.
The Honourable Senator Eggleton, PC.
No.
The Honourable Senator Hubley.
No.
The Honourable Senator Jaffer.
No.
The Honourable Senator Nancy Ruth.
Yes.
The Honourable Senator No.
Yes.
The Honourable Senator Tanis.
Yes.
Yeas pour 6, 6. Nays contre 3, 3. Abstentions, abstentions, nil, aucun.
The bill is carried. Does the committee wish to consider appending observations to the report?
Yes.
Should we go in camera for
Oh, I'm happy to do it in public.
the procedures? We go in camera.
We can do it. We're happy to do it in public.
Let's do it in public.
Well, I think it's terribly unfair to, if the steering committee has been working on some observations which I have not seen in a final form, that we would do it in public. If there are to be observations, I think we should have the courtesy to discuss the drafts, as we always do, in camera. We can return back for acceptance of the observations in public. But I think we should have some right to input them in the same manner as the steering committee did, which would be in camera.
Well, I don't see the need to suddenly throw everybody out and go into secrecy here. Aren't we a transparent organization? Now, let me tell you, I would have liked to have submitted these things in advance, but the suggestions come to me. Well, I won't talk about them now. I'm just talking about the procedure, whether we go in camera or not. I'm speaking to that. There were suggestions that came from UNICEF Canada that deal with how this might be administered, and these things I think are worthy of consideration. Now, I just saw these this morning, but I'm happy if you want to leave this over to another day, this whole matter to another day, and then I can give it to you all in advance. Okay. Oh, in camera. You want it in private, eh? You don't want to talk about this in public?
I think we can do the observations as Senator Chuck said. We can read them aloud.
I'll read them
everybody
aloud.
Can hear.
Thank you very much.
But right now...
That's very kind of you. I'll be happy to do that, but I'm happy to do that in public session. Well, wait a minute now. You didn't take...
To go in camera?
Camera.
I suggest that we do what Sandra Anuchuk suggested. We discuss the observations in private, go on camera to register them.
And then we come to public session and talk about them again.
Yes.
Yes. No?
Yes.
Oh, okay.
As you wish. But I think we have a precedent in this Senate, and it would be interesting that now you want that level of transparency.
Yeah.
I will be noting that in the record and certainly raising that when other committees will be asking for the right to have that kind of honest discussion before they then put their own points of view in a public forum.
Yeah, I think it's a good idea generally. I think it's a good idea generally. It's about time we got more transparent. Don't you think?
Is there agreement to go in camera?
Agreed.
Sure.
Okay. We need to suspend.
We need to suspend so we can have the room cleared. Thank you.
Honorable Senators, as you know, we had an extended clause by clause, and to inform you that instead of finishing at 4 o'clock, we will finish at 4:15. Honorable Senators, welcome to the 25th meeting of the second session of the 41st Parliament of the Standing Senate Committee on Human Rights. May I ask the witnesses that on the first panel to take their place at the table? Le Sénat a confié à notre comité.
The Senate has charged our committee with examining issues pertaining to human rights in Canada and genetic discrimination.
The other members to identify themselves. I'll start with the Vice Chair.
Senator Salma Dowlajan, representing Ontario.
Senator from?
Linda Frum, Ontario. Senator Andrew Chuck, Saskatchewan.
Senator Ngo from Ontario.
Senator Cowan?
Oh, I thought Senator Eaton.
Senator Eaton from Ontario. I was Senator.
Jim Cowan from Nova Scotia.
Elizabeth Hubley, PEI.
Art Eggleton, Senator from Toronto.
We are here to continue our hearings on Bill S-201, a private member's bill introduced by Senator Jim Cowan, the leader of the opposition in the Senate. Bill S-201 is called the Genetic Non-Discrimination Act. It was inspired by the rapidly growing field of genetics in the medical science, which increasingly is able, through a simple blood test or even a mouth swab, to learn if someone has a genetic predisposition to develop certain medical problems. In most cases, having a gene doesn't mean someone will develop a particular disease, but there may be steps one could take to reduce the chances of developing a disease if one knows one has a particular gene or genetic predisposition. However, right now, there is no specific legislation in Canada, provincial or federal, to address the problem of genetic discrimination, where a person is treated differently, for example, by employers or when applying for insurance because of one's genes. And in fact, many Canadians are choosing not to have genetic testing because of fear of genetic discrimination. That is what Senator Cowan's bill is intended to address. Honorable Senators, we are running late, and so we will extend our hearings to make sure that the witnesses get their full hearings. And to begin the study today, I would like to welcome the following witnesses from the Canadian Coalition for Genetic Fairness. We have Bev Haim Myers, Chair of the Canadian Coalition for Genetic Fairness and CEO of the Huntington Society of Canada; Joyce Gordon, President of Parkinson Society Canada and Chair of Neurological Health Charities; Mary Sunderland, Director of Research and Education Foundation for Fighting Blindness; and Richard Marceau, General Counsel and Senior Government Advisor, Center for Israel and Jewish Affairs. And a former member of Parliament. I understand you have presentations to make, and if I may please ask a favor of you, that if we will read your presentation, so if you can make them a little shorter, this would give senators a chance to ask you questions, but I leave that up to your discretion. You have 5 minutes each to make a presentation, and we'll start with Ms. Bev Haim Myers.
Thank you very much for inviting us, and thank you very much for listening to those communities that have experienced genetic discrimination and continuing this conversation. Today, my remarks are going to center around the global response to genetic testing and use of information, a barrier to early detection and treatment, workplace discrimination, addressing insurance industry concerns, and direct-to-consumer testing. The conversation is not new in Canada. When the Global Genome Project started, many countries, including Canada, engaged in a dialogue about where the Genome Project would lead. In Belgium, legislators and decision makers were informed by scientists and agreed that genetic information needed to be protected. Belgium, along with Austria, Denmark, Finland, Norway, and the Netherlands, implemented explicit legislative provisions prohibiting the use of genetic testing information for insurance purposes. During that time, Canada accommodated the insurance industry and agreed to take a wait-and-see approach. That was almost 25 years ago, and the industry is still asking for a wait-and-see approach. Since that time, a series of countries have acted, including the UK, France, the United States, and now Canada is the only G7 country that does not protect genetic information. Over the last several years, private members' bills have been presented, bringing legislation similar to other countries forward to end genetic discrimination. No bills have passed, yet all parties have addressed genetic fairness at some point and supported it. Science has outperformed legislation. It is time that Canada acted. According to public opinion research carried out by the federal government, 91% of Canadians feel that insurance companies should not be able to access their genetic test information for underwriting purposes. In my experience with Canadians and speaking to Canadians, they are shocked that we actually have to disclose our genetic test information to insurance companies. Genetic discrimination is a reality in Canada. It is well established that individuals shall not be discriminated against based on their disability, yet outdated laws still enable insurance companies to discriminate based on perceived disability or the prospect of a future disability. Current legislation does not address the concept of future disability or prevent discrimination. In a world where the Genome Project has led us to personalized medicine, making it possible for early prevention, detection, and treatment of many diseases, including breast cancer, genetic discrimination by insurance companies and employers is a barrier to the future well-being of all Canadians. In the case of Huntington disease, individuals from HD families cannot get life insurance unless they prove they do not have the genetic mutation. In one case, an individual went through the lengthy process of getting tested for the HD mutation. He did not have it, but was turned down for the life insurance because he might get it or could get Huntington disease. This is untrue and demonstrates insurers are not well informed. Less than 25% of Canadians at risk for HD choose to get tested. Most of the reason is because for fear of genetic discrimination. Research indicates that 86% of individuals at risk for HD fear genetic discrimination for themselves and their families. This is a sad outcome. Young families should have the right to make informed life decisions, like starting a family. We know that a person can delay the onset of HD symptoms if they lead a full life, including cognitive stimulation, physical exercise, and strong social interaction. We are also beginning clinical trials in 2015 that target the root cause of HD and have a potential to stop and reverse the symptoms of this disease. Why are we letting the barrier of genetic discrimination stand in the way of Canadians leading their best informed life and participating in life-saving research? Consider a healthy male in his late 20s. He and his wife are hoping to start a family in the next few years. He applied for life insurance. He is a healthy non-smoker and has no medical conditions. His parents and siblings are healthy and have no hereditary condition, are not known to have hereditary conditions. His application was fully declined because of ALS, Lou Gehrig's disease, originating in one of his grandparents. His parents are both healthy and have no signs of symptoms of ALS. He was further informed by the insurance company that the decision could be reconsidered if he should pursue genetic testing and prove to them that he has a negative result. This just happened. Less research has been done on workplace genetic discrimination in Canada. A lot of people don't come forward. In the paper Beyond the Patient by Dr. Yvonne Bombard, a significant number of individuals from HD families fear genetic discrimination by employers for themselves and their family. Dr. Bombard describes an example of her first patient who was tested for the HD mutation and had it but was asymptomatic. After this person's employer discovered the genetic test results, his responsibilities at work were shifted and he had no recourse. The case of the two brothers in their 20s at risk for long QT, a genetic mutation leading to a sudden fatal heart attack, is illustrative. One was tested, has the mutation, will be treated, and will accordingly not die of a massive heart attack. He will also not qualify for life insurance. The other brother was in the middle of a job search and refused to get genetic testing for fear of employers finding out. He will be able to access life insurance. Who wins in this scenario? When the untested, insured brother dies of a massive heart attack at the age of 40, leaving behind a wife and young children. Does it really make sense that an employer can inquire about a person's marital status, but can't inquire about a person's marital status, but can have access to private genetic information? Insurers have defended their right to genetic information by arguing that they need it to ensure their business models remain viable. As you know, research commissioned by the Privacy Commissioner of Canada concluded that banning the use of genetic test information would not lead to a significant impact for the industry. The insurers also believe that the Canadian consumer is different and prefers whole insurance as opposed to term insurance. The Canadian consumer is no different than consumers in all other countries that protect genetic information and have a thriving insurance industry. Like all purchases, we consider the products that are offered to us. Another concern by the insurance industry is that if individuals know their genetic status, they could benefit by buying large amounts of life insurance. A paper written by R.J. Thomas states that the concept of overinsurance is an attractive investment, where it may sound plausible, using realistic probabilities and premiums, suggests that in most realistic scenarios, overinsurance is not an attractive investment. In the UK, the claim was frequently made that if insurers were not permitted to use genetic tests, this would lead to a very large rise in the average insurance prices, or even the collapse of some insurance industries. That has not happened. As in Canada, these comments were not supported by the actuarial simulations of insurance markets, where genetic test results are known to the customers but unknown to the insurers. In summary, the point is made that the impact of not allowing insurers' knowledge of genetic tests made in the early 2000s has turned out to be greatly exaggerated. Evidenced by a thriving insurance industry in the UK, it seems that all is well, even though the industry has not had access to genetic test information for many years. We also welcome direct-to-consumer testing companies like 23andMe to Canada to profit from Canadians' curiosity with no regard for the predictable outcome of genetic discrimination. With the appropriate protections and cautions in place, in time, perhaps genome sequencing for $199 is a good thing. But for now, our government is allowing us to be misled. Genetic information is private, sensitive, complicated information requiring a high degree of protection. It must be used to prevent illness and save lives, not be used against people. Not protecting genetic test information and allowing insurance companies and employers to use an individual's most personal, complicated, and not very predictable genetic information will have a lasting negative impact on the health and well-being of all Canadians. It is time to make genetic fairness a reality in Canada and support Bill S-201, because no one has perfect genes.
Thank you very much for your presentation. May we please now go on to Ms. Gordon.
Thank you very much. Thank you for the opportunity to testify today to Bill S-201 to prohibit and prevent genetic discrimination. As a member of the Canadian Coalition for Genetic Fairness and as a member of Neurological Health Charities Canada, which is a coalition of 23 member organizations, as well as being CEO of Parkinson Society Canada, we applaud the Government of Canada for announcing genetic fairness as a priority in the 2013 throne speech, and for the opportunity to share our stories today in regard to this bill. Across Canada, there is a growing public and professional awareness and concern on the issues around genetic information and genetic discrimination. Genetic information, as you've heard from Bev, is personal, it's complicated, and it's often misunderstood. Genome sequencing might seem no less private than the detailed family history of diseases that insurance companies already demand. But as we get more and more information, it becomes a much more powerful means to assess someone's health. In addition, a person who chooses to map their genome gives up information not only about themselves, but about their parents, their children, their siblings, and other close relatives. Many are concerned about the impact not only on themselves, but their loved ones. The following is but one sample of comments by family members that we hear at Parkinson Society Canada, family members that have other family members with Parkinson's. Here's a quote from one of them. My father, aunt, and second cousin were all diagnosed with Parkinson's disease, and my sisters and I were interested in receiving genetic testing to see if we have the gene associated with Parkinson's. However, because we fear our children may be at risk of discrimination should a possible link be found, and that we may have difficulty receiving insurance, we decided against any genetic testing based on the potential negative impacts it could have. As you may know, the vast majority of cases of Parkinson's disease are sporadic, with no identifiable cause, which means no other family members have Parkinson's. However, approximately 14% of people affected by Parkinson's have a first-degree relative that is also living with the disease. 5 to 10% of the Parkinson community is affected by a genetic form of Parkinson's disease. There is no cure for Parkinson's, as for many neurological conditions. Canadians with a family history of Parkinson's may be at risk of being denied insurance and/or employment based on a future perceived disability. Some people refuse important genetic tests out of fear that their insurance company might gain access to their test results and begin charging them a higher insurance premium or not cover them at all. Establishing a genetic link is only part of the equation. Having a hereditary predisposition to a disease is by no means the same as having the disease and turning this genetic information and knowledge into a formula to assess and predict disease susceptibility, and it's complicated. There are many complex factors that influence the onset of a disease that analysis cannot take into account. Different genes can cause the same disease, and a massive 95% of the time one disease is actually the result of interplay among genes. For example, there are 28 distinct chromosomal regions related to Parkinson's, and it's complex with multifactorial causes. In Canada, as you've heard from Bev, outdated laws still enable insurance companies to discriminate based on perceived disability or the prospect of future disability. Insurance companies can use genetic information to determine eligibility, set premiums, and manage their risks. Definitive decisions can be made based on inaccurate, understood, and often unclear genetic information. This could mean being rejected for employment or loss of access to insurance coverage based on the notion that the individual may be disabled in the future. Current legislation permits insurers to ask applicants to divulge personal health information, including genetic data and family history, and to consent to having this information verified. This puts consumers under duress because they may be denied the coverage if they fail to do so. Genetic fairness protection is critical for Canadians with Parkinson's, especially since the Government of Canada has moved forward with personalized medicine research through Genome Canada, as well as Health Canada's recent approval of 23andMe, a saliva-based DNA service providing genetic reports on ancestry and family history. It would be interesting to see whether the companies offering these services and our healthcare system have enough resources available to make sense of the output and the impact of the information. Genetic testing should always be offered in a framework of genetic counseling and based on an informed decision by the individual. Canada is moving forward with genetic-based initiatives when we remain the only G7 country without formal provisions in place to protect Canadians from genetic discrimination. In Canada, we cannot discriminate against race, gender, or disability, but we can against DNA. Canada's lack of genetic fairness legislation is a barrier to citizens participating in health research, including personalized medicine initiatives. Genetics is a vital area of Parkinson's research with a hope of finding a cure and better treatments, but many are reluctant to participate in genetic research because they fear discrimination both from employers and the insurance industry. Personal genomics promises to be an everyday reality. We need to address the privacy, ethical, health, and economic issues surrounding genetic information and to put safeguards in place. Legislation in this area is imperative, and the neurological community asks the Government of Canada to enact legislation to protect Canadians from genetic discrimination to ensure genetic fairness. Thank you.
Thank you very much, Ms. Gordon. We will now go on to hear from Ms. Sunderland, please.
Good afternoon. Thank you for the opportunity to share the stories and experiences of the Foundation Fighting Blindness community. My name is Mary Sunderland, and I'm the Director of Research and Education at the Foundation Fighting Blindness, which is Canada's largest charity dedicated to supporting sight-saving research. I'm here today with two messages. One, genetic diagnoses are critically important, and 2, genetic discrimination is real for those who are living with retinal degenerative disease. As an advocate for the visually impaired community, I'm passionate about Bill S-201, but I'm also here as a mother. I have 2 sons, and my 1-year-old George was born with congenital cataracts. So although George is rather unlucky to have been born with this rather rare disease, only 20,000 to 40,000 babies are born with congenital cataracts each year, he is lucky because his dad, who has incredible attention to detail, noticed a strange cloudiness in George's eye. George is lucky because his dad noticed this in time for him to have surgery, which ultimately saved him from going blind in this eye. For children who are born with congenital cataracts, early diagnosis and treatment is essential. It is the difference between vision and blindness. Untreated congenital cataracts are the leading cause of treatable childhood blindness. This is because many of the children who are born with congenital cataracts are not as lucky as George. Cataracts are very difficult to identify, which means that many children go undiagnosed until it's too late for them to benefit from surgical removal. In addition, congenital cataracts are a symptom of more than 100 rare diseases. Just this summer, researchers published a breakthrough study which demonstrated that advanced DNA testing for congenital cataracts can identify the genetic causes of cataracts, sometimes diagnosing them as a symptom of another rare disease. So this early diagnosis is critical because it enables the early treatment. And this new diagnostic test is exactly the kind of novel intervention that we hope to support at the Foundation Fighting Blindness. But the trouble is there are serious and real risks associated with taking genetic tests in Canada. So knowing what I know now, would I have wanted George to have this test? The answer is no. Not until there are laws in place to protect him from the discrimination that I know exists. And I know that genetic discrimination exists because my colleague, Erin George, has been denied full long-term disability coverage because she has a genetically diagnosed disease, retinitis pigmentosa. This is a degenerative eye disease that gradually robs people of their sight. Erin did not expect that she would be granted coverage for her pre-existing disease. What really surprised her was that she was denied coverage for any potential future ailments that might require support from long-term disability. So because retinitis pigmentosa did not actually affect Erin until she was an adult, she is even more aware that unforeseen disabilities can strike at any time. This is precisely why she wanted to secure the best long-term disability coverage before her first child was born. But she was denied this coverage. Because of this, Erin has even more to worry about. She actually really wanted to be here today. She wanted to share her experiences of discrimination. But as a mother of 2 young children, including a new baby, she is sending her message through me. Bill S-201 is needed. This bill also matters to me as someone who is committed to building better treatment options for those who are living with retinal degenerative diseases. At the Foundation Fighting Blindness, we are about to support the first gene therapy trial for choroideremia, which is another rare form of childhood blindness. To be selected for the trial, participants enter their genetic diagnosis into the Foundation's patient registry. So what is one of the more worrisome risks of enrolling in the patient registry in Canada? Genetic discrimination. And in my role at the Foundation, I'm responsible for warning potential participants that genetic discrimination is legal and real in Canada. Bill S-201 has the potential to change this. We need Bill S-201 to ensure that Canadians have access to genetic diagnoses that are required for timely interventions. We need Bill S-201 to ensure that Canadians are empowered to participate in clinical trials without the fear or risk of genetic discrimination. We need Bill S-201 so that Erin has access to the insurance that she needs. We need Bill S-201 to prevent genetic discrimination in Canada. Thank you for listening. I'm very grateful for the privilege to speak on behalf of the Foundation Fighting Blindness community.
Thank you very much, Ms. Sunderland. May we now go on to Mr. Marceau.
Merci, Madame la Présidente. Je suis très
Thank you, Madam Chair. I'm very grateful to the committee for the opportunity to speak in favor of Senator Cohen's bill S-201 on behalf of the Center for Israel and Jewish Affairs, which is the spokesperson for the Federation of Jews in Canada.
for genetic fairness. CJA does not advocate for those affected by any particular disease or disorder. We are here speaking to the impact of genetic discrimination on hundreds of thousands of Jewish Canadians from coast to coast. I'm pleased to know that the imperative to prevent discrimination based on genetic testing benefits from a broad-based consensus which transcends political party lines. As you know, in the last speech from the throne, the Conservative government pledged to, I quote, prevent employers and insurance companies from discriminating against Canadians on the basis of genetic testings, end quote. An NDP private member's bill has been introduced in the House of Commons to amend the Canadian Human Rights Act to prohibit genetic discrimination. And of course, we're here to discuss Senator Cohen's bill S-201. As Bev noted in her remarks, Canada's wait-and-see approach has resulted in a serious legislative gap which no longer exists in any of our G7 partners or in countries like Israel, which has enacted comprehensive safeguards as far back as the year 2000.
In liberal democratic societies with free market economies, the 14 years that followed gave a clear indication that legal protection will not destroy the insurance industry, and it will not either provoke the bankruptcy of employers. Experience shows that these fears are unfounded. Rather, legislative measures, such as those proposed by Senator Cohen, would support leading-edge research, diagnostics, and treatments that could allow all Canadians to live in better health and to live longer. Genetic discrimination is not just an issue that affects individuals susceptible to develop certain diseases or health problems. Other ethnic communities are just as vulnerable.
Disproportionately carry genetic markers suggesting increased risk for certain types of cancer. Testing for this information, free from threat of discrimination, is crucial for improving health outcomes and saving lives. Centuries of Jewish endogamy have resulted in a relatively homogeneous genetic group, particularly among Jews of Eastern European descent, known as Ashkenazi Jews. This has led to significant genetic testing and research on so-called Jewish genetic diseases occurring in children like the Tay-Sachs disease. Genetic testing is already standard practice in much of the Jewish community, with young couples being screened for a panel of genetic diseases before marrying or having children. With the mapping of the human genome, new areas for genetic medical research have been unlocked. Promising new discoveries are being made at an exponential rate. These breakthroughs have a remarkable potential to impact health outcomes for Jewish Canadians. One such example is the BRCA1 and BCRA2 genetic markers for breast and ovarian cancer. Ashkenazi Jewish women are 10 times more likely to carry these cancer-causing variants than the general population, increasing their risk of cancer of up to 80%. While the Jewish community is the most disproportionately affected, we are not the only group at an elevated risk compared to the general population. La généticienne Marie-Claire King,
the geneticist Marie-Claire King, who discovered the BCRA1, recommends screening for all women, American women, aged 30 years or more, according to the Canadian Cancer Society. Screening and prophylactic intervention might reduce the risk of cancer for these women in more than 90% of cases. Given the prevalence of BRCA indicators in Jewish Ashkenazi women, this represents a priority for our community that could save lives. Unfortunately, there are practical screening obstacles to universal screening because of the possible denial of jobs or of coverage on the part of insurance companies founded on genetic discrimination.
Most frequent target of hatred and discrimination, According to Statistics Canada, our community has been victimized by hate and bias-motivated crime at a rate ranging from 15 to 25 times that of the overall population. Just as science has saved countless lives, it has also been wielded as a dangerous weapon to advance hatred and discrimination. While it's obvious that nothing of the sort is on the horizon in Canada, there's a real concern that those who cannot legally discriminate against Jews or other minorities based on race, religion, or ethnicity could do so based on genetics. La science a désormais dépassé la législation au Canada. Il est temps que le Canada reprenne son retard.
The protection of members of our society against discrimination based on the color of one's skin, ethnic origin, or ancestry should not be a Canadian value.
Sponsor of the bill, Senator Cowan.
A question for Ms. Ann Myers, if I may. In the course of your work, you're traveling across the country, and I know that you've met with provincial authorities, probably from coast to coast to coast, and discussed the gap that you see and the need for some intervention. Have you discovered any, uncovered, or heard of any opposition at the provincial level to this legislation?
No, absolutely not. At the provincial level, the question always is, what are they doing at the federal level? And I know that jurisdictions, the insurance industry, and it's always acknowledged in a meeting that the insurance industry is regulated at the provincial level, and that's accepted. But the provinces are generally waiting to see what's being done or what's going to be done at the federal level, and they will follow suit. And they're waiting with positive anticipation. It's not a concern. It's not a, you're playing in my backyard and you shouldn't be. It is something that they're looking forward to. And actually, when I'm speaking to the provinces, it would be most helpful if we had something at the federal level to help cascade down, much like happened in the States, where GINA addressed some of the discrimination, the Bill GINA, the Genetic Information Non-Discrimination Act, however, not all of it. And many of the states have implemented very stringent protection for genetic information. And that was a cascade effect. It was a good example set at the federal level and cascaded down to the provinces. So no concern has been expressed at all.
Another question, if I may? Thank you. I think Senator Nancy Ruth at one of our earlier sessions said, well, it's really a question of who's going to make money and who's going to pay, and whether are there winners and losers here, or is there some way that this could be seen as a win-win situation? How do you view it?
I think the win-win situation is protecting genetic information. I'll take you back to the example of the long QT syndrome in the family, and this is a true story, where the one brother was tested and he's found out to have the genetic mutation. He will be treated with beta blockers and live a good long life. He knows what to expect. He'll lead a good long life, but he won't get life insurance. The brother who is not being tested out of fear of employment discrimination and insurance discrimination could very well drop dead of a massive heart attack at the age of 40, leaving behind a family. Who wins in that scenario? No one wins. If we protected genetic information, both brothers were tested, both brothers would be treated with beta blockers going forward, and they both lead long, healthy lives. That's the win-win situation to protect genetic information. Also for our health care, every day there are new treatments discovered for many diseases because of the benefit of the Genome Project. We need to all benefit from that, and we need to be comfortable going forward, and we need people to come forward and participate in clinical trials so that everybody can benefit from the wonderful research going on. We don't need the barrier of genetic discrimination. So that is a win-win situation.
Thank you. Can I have a general question and perhaps throw it out to the panel members? It's also been suggested that there's no need for legislation, and that the Privacy Act, Canadian Human Rights Act, PPIDA, all that individually or collectively they provide sufficient protection. Could I ask you for your views on that viewpoint?
No, you go ahead.
I'll start. And then I'll hand it just very quickly. The current legislation is not clear. So people don't know that they're protected, and genetic information is not specifically stated. Right now, the onus is on an individual to prove that they have not been discriminated against and to prove that somehow they fall within PIPEDA or within the human rights somewhere. It's not explicit at all. We know from examples of other people who have been discriminated against in different ways that they feel violated. When a person feels violated, they're not going to come forward. So they don't come forward to go through the legal system to fight for this. We need to do something which legislation will do to stop discrimination from happening.
In terms of, there are incidental evidence that, in fact, discrimination is happening as with the current legislation. We believe, and I think that's I would speak for all the members of the Coalition for Genetic Fairness, that more protection needs to be added. Now, in terms of means, we have in front of us a bill that actually does that, despite the jurisdictional issues that Bev mentioned earlier. We're open to any suggestions that might make the bill better. But as we can see now, it's a pretty good bill. We're looking forward to having the government follow through on its commitment in the throne speech, in the last throne speech, to support discrimination, to support the fight against genetic discrimination. From where I sit, the fact that there's cross-party support from this, obviously your bill, the speech from the throne commitment, as well as Libby Davies' bill in the House of Commons, shows that there's a political will. The three political parties have identified genetic discrimination as a problem that exists now in Canada. There's a consensus across the board, so let's roll up our sleeves, identify the way to fight it, and let's make it happen.
Senator Os. Did anyone else? No? Senator Tulajan? Thank you, Chair. I thank you all for your presentation and for being here, and I apologize that you had to wait. Senator Cowan, when he spoke in the chamber, spoke that there's 10 years ago there was 100 tests, last April 2000, and now 13,800 for 4,000 conditions and 2,600 genes. So do we know of any countries which have taken steps to eliminate genetic discrimination, and how prevalent is genetic testing in other countries? I know specifically in UK it's quite high. So to anyone on the panel who would like to address that.
I'll go after first.
So we're the only G7 country that has not addressed it. So other countries, and I mentioned earlier in my talk, Belgium, other countries have addressed it, and they have put in specific legislation to protect genetic information. I think now there's closer to 23,000 genetic tests. So it is, and if you go into the web and look one day, 2 days later, it's increased by 500 tests. So this is an incredibly rapidly moving target, which is good for all Canadians if we can benefit from it. But yes, many countries, and in the UK, where they have implemented genetic fairness provisions, there has not been a kickback to the insurance company. They have survived. And the fear of that happening has not come to fruition. So we have examples of many countries where this has not been a detriment to the insurance industry or employers, but it has certainly been a benefit to the individuals.
And if I could add, I think what's happening is the science is outpacing the legislation. And as you've just heard, there is exponential increases in identifying genome sequencing, but we have not had the legislation and even ethical code support for what we need to do as this landscape is changing.
I just wanted to add, speak to a few of the questions that have been brought up in terms of how might this be a win-win situation and how common are tests. The test that I referred to when I was speaking about this new test in late August that was just published that you can do something with the congenital cataracts. They were suggesting that this should move to be a new standard of care, which never would have been possible a long time ago because the cost of doing the test was so important. But part of why they were arguing that it should be a new standard of care is because it has the potential to save so much money. Because especially with rare diseases, so much money is spent on trying to figure out what is wrong here and what is going on. And tremendous money is spent on trying to get an accurate diagnosis and on treatments that don't work because the diagnosis wasn't correct. So this opens the door to have really quick, efficient, and effective diagnosis, and then to spend money on treatments that will actually help the individual.
If I can simply add, I know the subject of Israel was raised in this committee. When in 2000 the State of Israel passed legislation to deal with genetic testing, they specifically in that bill made provision against genetic discrimination mainly in two fields, one in employment and one in insurance. In terms of employment, it prohibits the employers from demanding genetic discrimination or genetic information, or testing for employees or job candidates. And in terms of insurance, an insurer cannot ask any question about past genetic tests and results. They may not make use of any identified genetic information to refuse insurance coverage, and basically all this to say that individuals have a protected right to refuse to provide genetic information to an insurer without any penalty.
Senator Eggleton.
Right. Well, thank you very much for your presentations. Back when we had an earlier hearing on this matter, the Canadian Life and Health Insurance Association appeared. And they pointed out that there was an industry code that was they were volunteering to implement, and it's an 8-part code, and that they say their members will adhere to. It includes, number one, it will ensure that no Canadian will be asked to take a genetic test as a condition of obtaining insurance. I think it was on from there with a number of other complementary clauses. But it does point out that if one is taken, that it feels that kind of information should be shared. So, what are your thoughts about this this voluntary code by the industry?
It doesn't exist. I gave an example of the young man who was from a family with ALS, well, his grandparent. And he applied for life insurance, and he was denied because ALS was in the family at the grandparent level. Parents are not impacted at this point in time, and they're 20 years older than the grandparent was when that person succumbed to ALS. So what came back to that individual, and I hear this all the time, is if you can prove to us that you do not have the genetic mutation, then we will reconsider. So where they're saying there's a voluntary moratorium on asking people to get genetically tested, they will not even consider insurance until they come back with, I do not have the mutation. And in one case that I mentioned earlier with the individual who does not have the genetic mutation for Huntington disease, they were still denied because they might get it, which is very untrue. That does not happen. You have to have the mutation before it'll manifest. So they are saying there's a voluntary moratorium. So perhaps they don't say, please get a genetic test. What they do say is, we will not consider this unless you prove to us you do not have the mutation through a genetic test.
I see. Oh, yes. I'm not finished.
I'll put you on second round. We are really running. I'll put you on second round. Senator Frum?
Mr. Marceau, I appreciated your comment that this is a nonpartisan issue and it's something that there's support for among all the parties. The difficulty, as a number of you have mentioned, is just the issue of jurisdiction, and that if challenged, if this law was challenged, presumably by the insurance company, which it likely would be, it would be found to be unconstitutional because there is no federal jurisdiction over insurance regulation. So, Ms. Hahn-Myers, you made reference to the work you've done talking to the provinces, but I'm just interested in the approach about a provincial approach versus a federal approach in terms of actual law and regulation. Doesn't it have to come at the provincial level?
From a regulation perspective, does it have to come at the provincial level?
Yeah.
I think that we need both. I think we need it at the federal level and the provincial level. I think that we need to set the example at the federal level, but from a regulatory perspective, the insurance industry is regulated at the provincial level. The challenge with not having the umbrella of at the federal level of protecting genetic information and setting that example is you don't want piecemeal across Canada. We don't want one province to protect it and another province not to, because that will just create confusion and inequities for individuals applying for insurance. So if we have an overlay at the federal level of protecting genetic information, then it will be more respected at the provincial level in moving forward. And I don't see an issue with that at all moving forward at the provincial level, given the conversations I've had with provinces already.
Senator, I do appreciate the question, and yes, insurance is indeed provincially ran or provincial jurisdiction. I think what we're looking for here is a signal that that would be sent all across the country. As I said in the previous answer, the way the signal is sent is not as important as it is sent. And I understand from conversation with the people of the government that that's what the government is trying to wrap its head around. Like, it's in its speech for the throne. It's okay. Now we want to fight this. Now how can we make sure that it's fought in the proper way and it's not it doesn't it's not contested in front of the tribunals. What we're saying is that this bill is a way forward. If there's some ways the government wants to amend to make it better, to make sure that it's all fair and good, but the signal is important. It's signal sent to the insurance industry, to the provinces, to say this problem is real. And I go back to the first comment that you made to me in your question. There's a political will to make it happen. And as Bev said, the will is also there at the provincial level. But at some point, somebody has to say, okay, let's do it. And we're looking at the federal government to be that person, to be that the one who will light the fire to make sure that this thing is, this protection is put into place as soon as possible. And Senator Cohen's bill is a nice way to get the conversation going and make it happen.
Senator Hubley. Thank you very much, Madam Chair. And again, thank you for being here and your presentation. I'm wondering, in your experience, if you've seen an increase in the amount of medical information that is being required by companies. And as you say, they are moving into not insisting on genetic tests, but certainly implying that that is going to be an important piece of information that they would like to have. Have you seen a major increase in businesses over the last while?
It's very hard to measure because people will not come forward. I've seen an increase in anecdotal information where people have come to me to say that when they are being promoted to a different level in a company, where that information is being requested or looked at. But it's not evidence-based research. People don't tend to come forward when this is used against them in an employment setting. So it is anecdotal. I'm sorry, I don't have the research there. And I had mentioned that earlier. There's not a lot of research because people do feel violated, they feel embarrassed, and they feel out of control. And there are many situations where people are in different situations and they don't come forward. So there's precedent. Yeah.
Okay, thank you very much, Madam Chair. Thank you.
Thank you. Senator Eggleton.
Oh, I was interested in Mr. Marceau's comment that this was a signal, because I heard people say that about the last bill, S7, that it was a signal. And even though the provinces would be very much involved with well, it still was a good signal. The majority of the committee said, I couldn't resist saying that at this point in time, just so you remember it when we come to dealing with this bill, and clause by clause. Anyway, sorry, didn't mean to really get you involved in that, but it was for my friends over here. I want to ask you about the United States, the GINA project. Where do you? It's been around since 2008. The act was passed in 2008, and as you point out, a number of states have adopted various measures on discrimination on employment or on insurance. How do you? It's always good to learn from what other people do. There has been some mention of the UK experience, been some mention of the Israel experience, but let's talk a little bit more about this United States experience. Where do you see the pluses and the minuses in terms of that legislation?
the GINA legislation, the plus would be people had access to health care, the health care and disability insurance. What was dropped off the table with GINA was life insurance. So where the insurance industry stood beside them in this legislation, the only way it would go through is if they dropped the life insurance part of GINA. So the example for the rest of the states is that's been picked up, especially California, very comprehensive. It's a very comprehensive protection. It would have been wonderful in 2008 with GINA going through, and this is what they were working towards, was to have life insurance and disability insurance included together. But that wasn't. So the good news is that there is coverage, but they don't have the life insurance. However, the states have followed suit. The individual states, like California, have picked it up and implemented much stronger genetic protection legislation. So it was a very good example. It was a signal. It was a validation that genetic information is complicated and personal information that should be owned by the individual and not used against that individual, but only used as that individual sees fit to have that information used. So all of that is excellent, and all of that is a good thing, and it was a good message.
Okay, well now the insurance industry in Canada seems to think that it's possible that the premiums would be increased here, the costs would be increased. Is there any evidence that the industry in the United States is panicking over this?
No, and the contrary, in the paper that I referred to in my talk in the UK, where that was a fear that premiums would increase. In fact, it hasn't. And it hasn't because monogenetic diseases are rare. So Huntington disease is a monogenetic disease. It's on one chromosome. It's very definable, but they're rare diseases. There's not many of them. The multifactorial diseases, like Parkinson's, being multifactorial, the chances, because this is based on a perceived future disability, it's not coming to fruition and it's not happening. So there hasn't been an impact on the insurance premiums. That fear, historically in the UK, has not come.
Is there any evidence about it increasing? I would think it would decrease health care costs, simply because if you have a genetic test, you get it early enough, you can take preventative action. We had Dr. Ronald Cohen here at a meeting recently, who's in genetic medicine at the Hospital for Sick Children in the University of Toronto, and he said how much different he thinks the costs in healthcare would be if you can catch it early, if you have the genetic test and catch it early. And I take it you would agree with that.
Oh, absolutely. There are liver diseases that if you catch it early, it'll never manifest in an individual. And with Dr. Cohen's example, not only if they don't have a test now, we know, I think when he talked and there were 56 tests for known genetic diseases in children, and within 2 weeks it increased to 58. So it's not only understanding now how a child can be treated, but it's understanding how that child can be treated in 2 weeks when we have a treatment for that disease. So absolutely, it will lead.
Senator Eaton has a supplementary.
Yes, more to supplementary to Senator Frum's question to Monsieur Marceau. You were saying in your response to her that there are certain diseases that are more prone to the Jewish community, I think more certain cancers. Could you not say that to other communities? Isn't sickle cell more prone to the black community, for instance?
Yes, there's absolutely certain markers that are more prevalent in some communities. For example, South Asians tend to have a higher rate of heart diseases or diabetes. So there are absolutely certain groups that are more prone to having certain diseases. Obviously, I illustrated this by the Jewish community, but other groups are also carrying some genetic defects more than others.
And I think this has been known for some time. Has the insurance companies ever discriminated against certain communities because diseases were more prevalent in those than in others?
Not to my knowledge.
Thank you.
I want to thank all of you. As you can see, there's a lot of interest. There are many more questions that my colleagues would ask. What I would ask of you is that if there's anything that we haven't covered, may I ask that you submit that to us in writing so we get a fuller picture. And I once again want to apologize to you for keeping you waiting, and we certainly have learned a lot from you. Thank you very much. We'll take 1 minute break to get the next panel on. Again, I'm very happy today to welcome the Canadian Association of Genetic Counselors, Claire Gibbon, the Genetic Counselor, North York General Hospital, and Julie Ruthberg, Genetic Counselor and Research Coordinator, University of Ottawa Heart Institute, and the Canadian College of Medical Genetics, Dr. Gail Graham, President and Chief of the Department of Genetics at CHIO, Center of Genomics and Policy, Professor Yan Jolie, Associate Professor, Human Genetics, McGill University, and 23andM Inc., Kathy Hibbs, Chief Legal and Regulatory Officer. And we'll start with you, Ms. Claire Gibbon. And may I ask that you please keep your remarks to 5 minutes so we can get extensive questioning. Thank you.
Sure, no problem. So thank you so much for allowing me the opportunity to testify at this committee on behalf of the Canadian Association of Genetic Counselors. I'm joined with my colleague, Julie Ruthberg. We are both genetic counselors and wanted to give just a little bit of background about genetic counseling. Genetic counseling are medical professionals who provide families with information about genetic conditions, their genetic risks, and genetic testing. We strive to help patients understand the pros and cons of having genetic testing, and our focus is for patients to understand this information so that they can make the decisions about testing that are best for them and their circumstances. So as such, the Canadian Association of Genetic Counselors had decided to make a position statement to draw awareness to the issue around genetic discrimination and to call for legislation to protect Canadians, because we feel that this is a very important issue and it is affecting our patients on a daily basis. We polled our membership to find examples of circumstances where they felt that there was genetic discrimination and unfair use of genetic information. Most of our responses focused around insurance discrimination. We had very few specific examples of employment discrimination. So I'd like to share one of the most surprising examples that was sent to us, and it has to do with a condition called hemochromatosis. Hemochromatosis is caused by having mutations in both copies of a particular gene, and this predisposes people to have iron overload. If the iron overload becomes high enough, this can cause debilitating symptoms and in some cases death. However, people with the two mutations, only a very small number of them ever develop iron overload enough to cause symptoms. And people who are aware of their genetic status are able to make simple lifestyle adjustments to minimize their risk for developing iron overload. For example, reducing the amount of iron in their diet, being cautious about the type of vitamin supplements that they take. And with this knowledge, they can have routine iron monitoring through their physicians, who, if they find that their levels are beginning to rise, can have a simple treatment called phlebotomy, which is bloodletting, which will bring their iron levels back to normal levels. So this is considered to be one of the most preventable genetic conditions. So I was very surprised to have a number of reports of people across Canada who were denied life insurance and in one case travel medical insurance because of their genetic testing for hemochromatosis. These people did not have any evidence of iron overload. So this was very surprising, and you may think, well, this is a rare condition, so how many people would this affect? It actually is not a rare condition. About 1 in 300 people of Northern European descent would have the same genetic makeup that these patients had that were denied insurance. Just most people are not aware that they carry these mutations and their status is unknown. So, in this case, having the genetic information made it less likely that these people would develop symptoms, but was used against them. This is just one example of how genetic test results can be used unfairly and inaccurately. And just having a few cases of these means that we have some distrust of how our genetic information is being used. And because of these cases, genetic counselors feel that they must inform every patient who's going through predictive testing about the potential risks that they could face when their genetic information is used against them. Also, there's no guarantee what would be used in how this information would be used in the future. So even if right now we can say we're not aware of many cases of discrimination from employers, we have no proof that in the future that this wouldn't happen without some type of protection. As mentioned before, it is also impacting on people's participation in research. In all research consents, we are now required by many of our institutional research ethics boards to list under disclosure, under risks, the disclosure of medical or genetic information that could in some way be used to discriminate against them. Even though many of the research take many precautions to minimize or prevent this from happening, it has to be listed on the consent form, and this often causes concern for the potential participants, and also is really reinforcing that level of concern and unease about the possibility of genetic discrimination. As interpretation of genetic results become more complex, and we've been focusing on single gene disorders here, but as I'm sure will come up with the 23andMe talk, there are companies that are available that will kind of adjust your overall health risks based on certain genetic studies. Some of these have limited scientific validation, but people are still interested in finding out this information. It's much more complex, and the predictive value of these tests are questionable. But again, there's no protection about these being disclosed to an insurance company if they decided that they would like to ask for it. It is difficult to believe, given the examples that we've already presented, that self-imposed moratoriums, audits, or codes by insurance companies will provide enough protection for the people of Canada. The consequences of this fear of genetic discrimination is that people are avoiding testing for treatable conditions like hemochromatosis and some of the hereditary cancers. They're also avoiding participating in research, and families may be reluctant to share their genetic information and their genetic risks with other relatives, thereby keeping those relatives in the dark about their potential risks and not allowing them to make their own choices about genetic testing and treatment options. There are many examples of when insurance companies may use other information in an unfair way, but many of these not many of these do affect people's medical decisions, whereas this one is. In other words, if I have a lump in my breast, I'm not going to say, I'm not going to go to my doctor to have this checked because I'm afraid of, life insurance discrimination, but people are not taking the BRCA1 test to find out if they have an increased risk of breast cancer because they fear genetic discrimination. the Canadian Association of Genetic Counselors believe that Canadians need protection from genetic discrimination, and the best way to accomplish this is through legislation.
Thank you very much for your presentation. We'll now go to Ms. Gail Graham to make her presentation, please.
Thank you very much for the opportunity to comment on Bill S-201. I very much commend Senator Cowan for his leadership in this important initiative. I recently assumed the role of the president of the Canadian College of Medical Geneticists, the CCMG, and we are the professional organization that represents doctors who order genetic tests for patients and the laboratory scientists who make these tests possible. And while the timeline of my involvement hasn't allowed for a complete survey of our membership, I can tell you that I've discussed this bill with our board of directors, including our vice president, Dr. Judy Chernos, and the chair of our Education, Ethics, and Public Policy Committee, Dr. Julie Richer. We all agree this is a complex issue, and we are extremely pleased that Bill S-201 has been put forward as an important first step in protecting patients from genetic discrimination in both employment and insurance settings. There are really 4 different contexts in which a patient may undergo genetic testing, and I'm just going to walk briefly through each of them. The first is that an individual is forced to take a genetic test or to disclose the results of a previous genetic test as a condition of employment. Bill S-201 will protect individuals from this unwarranted invasion of privacy, a protection that is long overdue and that exists, as you've already heard, in many other countries. The second is that the individual has clinical manifestations suggestive of a genetic condition and undergoes what we would refer to as diagnostic testing as a patient in the context of our healthcare system. The third is that the individual has a family history of a genetic condition and seeks to establish whether they will develop this condition, once again, ideally in the context of our healthcare system. We refer to this as predictive testing, and really it can enable crucial life decisions. So a 20-year-old patient who has a 50% risk of developing an inherited form of visual disability, for example, may alter his career choice if a genetic test confirms that he will lose his sight. A woman who has a 50% risk of developing an inherited neurodegenerative disorder for which there is no cure may choose not to have children if a genetic test confirms that she will develop the disease, either because she doesn't anticipate being well enough to raise those children or because she does not wish to pass on the disease. And similarly, a woman at 50% risk to have an inherited cancer predisposition syndrome may choose to learn her status using a genetic test in order to enable medical surveillance measures to help diagnose that cancer at the earliest possible opportunity. So every single day, medical geneticists see the threat of insurance discrimination influencing patients' choices about whether to have a genetic test in both scenarios 2 and 3, the diagnostic and predictive scenarios I referred to. And admittedly, the degree to which any bill can address existing insurance discrimination in those contexts depends to a certain extent on the insurer's requests for the patient's medical records and family history information, both of which can prejudice an insurance application even in the absence of a genetic test. Nonetheless, I am absolutely convinced of the need for this bill and also the important protection that it could provide. To understand the last of the 4 contexts I referred to earlier, you must appreciate that new genetic technology is literally revolutionizing medicine. So in the 1990s, it took more than a decade and hundreds of millions of dollars to sequence the first human genome, and now it takes less than a week and about $1,500 to sequence several human genomes. And these technological advances, which are due in part to the investment of public funds in research, have given us the ability to simultaneously analyze the important coding information in all of the approximately 23,000 genes in our genome. This technology is already beginning to be used to diagnose genetic conditions that are so rare that they have only been reported in a handful of people around the world. And in fact, even right here at CHIO, we have used this technology on a research basis to diagnose conditions that have never been described before, unique single gene conditions. The technology is also finding a key role in the profiling of non-inherited cancers so that treatments can be targeted to the genetic mutations that caused an individual's tumor. It is incredibly powerful technology, and it is the future of medicine. And this is precisely why hundreds of millions of dollars were spent to sequence the first human genome. Therefore, the fourth scenario is one in which a patient undergoes testing using this new genome-wide technology, ideally in the context of a medical encounter, and a serious genetic condition is detected as an incidental and otherwise unexpected finding. Medically actionable incidental findings have only been reported in 1 to 2% of individuals in large cohorts who have had this type of testing, and in many such circumstances, as has already been pointed out, this knowledge allows patients to minimize or prevent morbidity by undergoing surveillance measures and/or treatment. This incidental finding scenario represents a very small risk for the insurance industry, a risk that is disproportionate to the burden to our population if fear of insurance discrimination prevents us from using these powerful technologies for healthcare. We must ensure that promising new applications such as cancer genomics are not impaired by the fear of insurance discrimination. The time to take action is now, as this technology is about to become a routine part of medicine. If we wait, as we have already, it will be too late. As a medical geneticist, really the most important part of my job is to see patients who are suspected to have or have a family history of a genetic condition. Most of these are rare, as you have already heard. Not a single week goes by that I am not explaining to a new patient who is considering genetic testing the potential implications of that choice on their future insurability. Last Thursday, I saw a 50-year-old woman who came to attention because of an unusual skin finding. The nature of that skin finding raised the possibility of a rare condition called hereditary leiomyomatosis and renal cell cancer. She chose to decline genetic testing that could confirm an increased risk of an aggressive form of kidney cancer because her employer changes frequently, and every time her employer changes, she has to apply for new insurance. A genetic blood test could tell her with certainty whether she has this condition. If the test were positive, she would require annual screening for kidney cancer, the intention being to find a cancer as early as possible when the treatment outcomes are best, and if the genetic blood test were negative, her risk of kidney cancer would be reduced to the point that screening would not be warranted. Her informed choice not to have genetic testing means that a genetic blood test cannot immediately be offered to her 3 offspring, all of whom are young adults and each of whom has a 50% risk of having the same condition. Those 3 young adults will have to wait to see if they develop the skin findings or the cancer itself. This is a real-life example of what happens every day in Canada because we do not have a law like Bill 201, S201. Patients must be able to undergo genetic testing for the sake of their own health and that of their children without fear of insurance discrimination, and they must be able to do so when it is medically necessary without regard to whether their employment or insurance situation could change. Short of actually providing a cure for these conditions, this is the most important thing that the government could do for my patients and for the patients of my colleagues all across the country. So thank you very much.
Dr. Graham. We will now go on to Professor Jory, who's from the Center of Genomics and Policy. Professor Jory.
Thank you very much. Good afternoon, and thank you for providing me the opportunity to testify on Bill S201 and to draw the attention of the committee to certain elements relevant from legal, ethical, and public health perspectives. I'm a lawyer, member of the Quebec Bar. I occupy the position of Research Director at the Center of Genomics and Policy. It's an academic research center that's established by Canada's Research Chair in Law and Medicine, Professor Barton Knoppers at McGill University. Centers comprise more than 30 researchers and research students that provide multidisciplinary research and expertise on the socio-ethical and legal policies underpinning genomic research and medical research in general. Our center was a pioneer in addressing the issue of genetic discrimination, bringing it to the attention of the Law Reform Commission of Canada already in 1991. So that is 23 years ago already. And we've done some of the only international comparative review when we heard about the discussion of the various laws in other countries. Some of this is the product of the center as well, these analyses. In Canada, despite the lack of strong evidence supporting the existence of discriminatory practices based on genetic information outside of the context of Huntington's disease, and I'm saying this because I did conduct the only published systematic review of all the reported genetic discrimination events presented in the literature. So the only area where there was strong evidence of discrimination was concerning Huntington's disease, and some evidence also in the case of hereditary breast cancer. So despite strong empirical evidence that there is genetic discrimination in general, there is some concerns in the population, and we recognize that among patient group, professional association, the media as well, and we're sensible to these concerns. But we would like to reiterate that in most instances, the problem of genetic discrimination has more to do with concerns over possible risk than about actual documented case of genetic discrimination. And when there are areas or specific disease that are really affected by genetic discrimination, maybe they would be better protected through administrative measures rather than broad federal legislation. We have three main recommendations to make if this bill should move on. We strongly support, and that's the first recommendation, the adoption of a prohibition on genetic testing of individuals as a condition for accessing goods and services such as insurance. That's common sense. Imposing genetic testing on individuals goes against fundamental principles of the Canadian society, such as the respect for human dignity and individual autonomy. The insurance industry also agrees with this. Therefore, the proposed legislation would effectively strengthen an already existing policy beyond industry self-policing, thereby providing a greater degree of accountability and helping to appease popular anxiety on the matter. Our second recommendation is that we believe that the prohibition on the disclosure of genetic test results should be confined to research genetic test results. And why do we think that? Well, first of all, genetic test results obtained in the context of health research, and I make a distinction between research and clinical care. Well, the ones that we obtain in research often do not meet the threshold of analytical validity, and clinical utility, and their use also generates unforeseen legal and ethical issues. In addition, genetic research results are by their very nature difficult to interpret, and they can often be contradicted by later studies. And we note again that the latest code of conduct of the insurance industry, the one that was presented to this committee earlier on from 2014, agrees with this, and that the code states that the results should not be communicated to the insurer if the doctor hasn't had access to the result as well, and if this is not clinical, if these are not clinical results. So again, it's just a matter of reinforcing something that's already agreed upon by the insurance industry. Why do we think that we should stop at research and not go to case of clinical genetic test? Well, first of all, there's this lack of evidence issues, and also, given the lack of evidence, we just don't think it's necessarily the best solution, and there's a big challenge of coming up with a legal instrument. We were talking about the fact that law was running behind science, and I totally agree with that. And that's one of the problems of making a bill like this one. I can tell you as an example that the definition of genetic test that's proposed by the bill already is likely not to capture what we call epigenetic and epigenomic data. And epigenetic data is basically how genes can be turned on and off in the organism, and it affects, again, your chance of developing disease and the way you react to different medication. And right now, this is where a lot of genetic research is going, to the epigenome. Well, likely this law, as it's currently framed, wouldn't protect people from discrimination based on epigenetic data. So an instrument that would be more flexible, easier to change in the future, might be better suited to protect people than this sort of law. Again, we also think that genetic information should not be presented to Canadian citizens in an overly negative light as something that leads to stigmatization and that's more sensitive than other types of medical data and would need exceptional protection. We also would like to point out, and on a final note, the impact of the bill would be minimal right now as it currently stands for Canadian citizens. It's not going to protect a lot of people. We've pointed out the constitutional limitation, and they're very serious limitation. It should be remembered that areas where cases of genetic discrimination are the most likely to manifest themselves are situated within provincial fields of competence, for example, private insurance and employment outside of the government sector. Adoption as well. We haven't talked about genetic discrimination in adoption. There are other fields where it can manifest itself. Therefore, they would be beyond the reach of the bill. The only positive impact that the bill might have is that it could generate a synergistic effect that would facilitate the adoption of similar complementary legislation by provincial policymakers to better protect citizens. So I agree that there's an issue. I'm just not certain that the current bill, especially as it is presently formulated, is the best solution to address it. Thank you for your time.
Thank you very much. Maybe please go on to hear from Ms. Hibbs.
Hello, I'm Kathy Hibbs, the Chief Legal and Regulatory Officer for 23andMe, which is a leading personal genetics service provider. 23andMe strives to provide people with access to understand the benefits and the information from the human genome. I want to thank the Senate Committee for inviting me today to speak about the important issue of genetic privacy, as we provide people with a service linking them to their genetic information, and we recognize the sensitivity of this data. 23andMe recently introduced an improved version of our personal genome service for Canada in September of this year. That service, which is based on a saliva collection kit, is used to take DNA samples from individuals, and we provide those individuals with over 100 reports of genetic-related information. The health reports which are included focus on individual genetic markers with well-established relevant associations that can be incorporated into an individual's health care plan under the guidance of appropriate professionals. People also use genetic information to learn about their genetic ancestry, traits such as lactose intolerance, male pattern baldness, whether they're at risk of passing on an inherited condition through carrier status, how they might respond to certain medications, and other genetic factors which can be managed. However, genetic science is at a very early stage, and 23andMe is the world's largest online platform for genetic research, helping to accelerate the pace of those discoveries and advancing the understanding of human health. For those of our customers who consent and participate in research, we have contributed to over 230 studies, which are providing useful results. Our Parkinson's research identified 2 new genetic mutations associated with the disease within 18 months of being launched. To date, more than 25,000 Canadians have used our service, 20,000 of those prior to the launch of our service in Canada in September, and approximately 80% of those Canadians have participated in research. We do believe that genetic information should be protected. It's important for people to have access to their genetic information, and to do so and to harness the power of that information, they must feel that it is protected. We do know from our studies that many people, when presented with genetic information, have changed positively their behaviors to improve and prevent disease and improve their overall health. In addition to the health information people receive, people do learn about their family relationships, and we do believe that in order to fully be able to participate in the genetic revolution, they have to feel comfortable that their information is protected. We've been longtime supporters of legislative efforts to prevent genetic discrimination and safeguard genetic privacy. In the U.S., we were active in the development of the Genetic Information and Non-Discrimination Act, or GINA, which was enacted in 2008 and is similar to S201. Prior to the enactment of the Genetic Information Act in 2008, discrimination by employers and health insurance companies was a concern for people interested in learning more about their genetic makeup. In addition to supporting the U.S. federal non-discrimination legislation, we have also supported the California Genetic Information Non-Discrimination Act, which was enacted in 2011, and as Ms. Heim-Myers has noted today, provides substantially greater protection than is provided at the federal level. 23andMe supports S201 and its underlying principles of preventing genetic discrimination in the Canadian insurance and employment context. We've sent a letter to this committee with regards to our support, and we hope to see a bill passed. I welcome the opportunity to answer any questions you might have.
Thank you very much, Ms. Hibbs. And we'll now go to the sponsor of the bill, Senator Cowan.
Thank you, Chair. Thank you for your presentation. I had a couple of questions for Mr. Joly, if I might. You mentioned that your preference for sort of a voluntary code rather than a legislative intervention. But isn't it a fact that in countries like Germany and Finland, where they went first with the voluntary code of conduct, that they have moved away from that, having had that experience, that they have now passed legislation in place of the voluntary codes? Isn't that a fact?
So if I may clarify, I'm actually not for a voluntary code. I believe I'm for a more flexible solution. There are solutions such as a moratoria like the one that exists in the United Kingdom, where both the government and the insurance industry have agreed upon a code of practice. And so I find that this is the best compromise, because you have a model where you have a flexible solution, something that can be changed quickly, revised over the year, and updated. This, I think, would be the best model. I agree with some of the issues that previous speakers have raised regarding voluntary code of practice, which is it's very nice in theory. Does it really work? I think it's something that can be certainly observed for a while, but I'm not certain it's the best solution.
In December of 2012, you wrote in the Globe and Mail, and I quote, "In Canada, genetic discrimination is closer to myth than reality." And you went on to say that data convincingly demonstrating its systematic existence have been found only in the context of Huntington's disease, a rare condition. I don't know whether you've changed your view since 2012, and I'd invite Dr. Graham and Ms. Gibbons perhaps to comment on that because they are at the front lines in this business.
Well, I think one of our previous speakers made the point. The point is that the problem exists, and it exists every single day in my clinic. It's a discussion I have 2 or 3 or 4 times a day with patients. And the reason that the evidence is anecdotal, and that you're hearing from so many people today that it is a problem, and not published in journals, is precisely because patients are not overt about that problem outside of the context of their therapeutic relationship with their doctor or with their genetic counselor.
Ms. Gibbons, do you comment? I'm sorry.
You want to go first? That's fine.
Sure. I agree that there's probably a lot of cases that go unreported, and I'm certainly not suggesting the contrary. However, what I can say based on the way that a lot of people are reporting cases, you have to make a distinction on, for example, in many cases, insurers will actually ask the information. And so people will say, I've been discriminated because somebody has asked me the information. But in many of those cases, nothing happens next. You provide the information and you still get access to insurance. Then there are other cases. Moving on to the next stage, people saying, I've actually been discriminated, refused insurance. You investigate those cases. Again, a large proportion of those cases are people that actually had a pre-existing condition. Yes, they had a genetic mutation, but they also had the disease, actually. So then it's another question that you're asking. And so we have, it's very difficult, and that's why it's so difficult to legislate on this question. What are we trying to prevent? Are we trying to prevent discrimination based on genetic predisposition, discrimination based on genetic disease? And if we are, why genetic disease? And why not discrimination based on health information? Why should we make a distinction between those cases? So that's where I find there's a very it's very difficult to draw the line. And my study was really only about the cases that were reported. So I do agree there's certainly additional unreported cases.
Yes, thank you. When we polled our membership, we got a lot of feedback from people from a variety of genetic conditions, not just Huntington's, and we expected Huntington's would be the primary one. I do want to state that even treating all people with the Huntington's mutation the same is unfair as well, because Huntington's is caused by an expansion of the DNA sequence within the gene, and the size of the expansion can predict to some degree the age of onset. So to even just say, okay, well, you know, in Huntington's, everyone who tests positive is excluded is also unfair, and that you really have to look, if you're going to look at genetic test results, you have to know what you're looking for and look at them fairly. We've shown cases of the hemochromatosis where, again, reports where the people didn't have a pre-existing disease, but because of their test result were discriminated against. And the issue is the sampling, in that I know the amount of work that Dr. Bombard went through to try to poll the Huntington's group. So trying to get hemochromatosis, the heart condition, you know, trying to get all of them to get a really good sample size is very difficult. And I think that, you know, yes, the fear outweighs the actual cases, but the fear is also for what could happen in the future, because we don't know, you know, we can be promised that things won't change in the future, but we have no guarantees. And that is, I think, what the Canadian public would like to see is some kind of protection, so that we don't have to have this fear. Have you got another? No? Senator Frum?
Mr. Joyce, can you just elaborate more on the UK model? Because as you're saying, as we're all acknowledging, the constitutional problems with the bill are clear, but the problem is also extremely clear. So in terms of trying to find a proper federal solution to this problem, can you just explain what the moratorium exactly, how that works exactly?
Sure. So the moratorium is an agreement, it's a binding agreement between the government of the United Kingdom and the insurance industry of the United Kingdom. I think it's being revised now every 5 years. So it's basically working for 5 years, and every 5 years they review the terms. And also it has been made very clear to the insurance industry from the start of this moratorium that if there were issues, and they are documenting also the efficiency of this moratorium quite well, then the government would step in and adopt legislation. So it's definitely an instrument that has teeth and that can be enforced on the insurance industry. And what's very interesting is it's actually much more detailed in what it does, what it doesn't do, what it seeks to cover. For example, there are limits depending on the type of insurance, the type of amount of insurance that you want to have, the type of disease that you're targeting with this moratoria. So it's a much more flexible solution to address the issue. And I really think this is what's needed with something that evolves so quickly. As was pointed out by Katie, we're only at the beginning of the genomic revolution, and it's very difficult. So we were talking about evidence. Well, in the case of personalized medicine and complex condition, there's just absolutely no evidence of what's happening with genetic information, and if there are any types of discrimination at all. So we're really early on. So it's also nice to know that we can adopt something right now, but be able to review it and change it later on if it doesn't work well.
You also made the point about distinguishing, if you want to prove a case of genetic discrimination, it'll be very hard to prove a case when there's also pre-existing condition, and so the insurance company can say, there obviously could be great points of difference.
Yes.
And it becomes a very difficult case to prove that why you were turned down for this reason versus that reason.
Absolutely. There's no transparency right now. The insurance industry is very nebulous in how it arrives. We know it's based on actuarial table and actuarial evidence, but how do insurance industry arrive at a particular result? it's almost impossible to tell. And even, when there's a law like this one, and we can see it, so a lot of countries have adopted a lot of law. That's absolutely certain. Are those laws effective? We really don't know yet. Are they really addressing the problem? We don't know yet. And one of the reasons for that is that even if you have a law, an insurer can always tell you, well, we're refusing you for this or for that, or they can simply, wait before they respond to your inquiry for an insurance contract. Wait and wait and wait until you get tired of them waiting and you move on to another insurer. So there are other ways for them to go around these types of legislation. And not everybody also, has the access to a lawyer and is willing to go to court to have their right enforced. So it's all these things we have to think about, I think, when we try to find the best solution to address an issue that I really believe do exist and should be addressed.
Senator Eggleton?
Senator Cowan asked my question, so I'm fine.
Senator Eaton?
I'm just wondering whether two professors, Dr. Graham, Dr. Joly, using genetic information with health costs soaring, do we have any data, or are we beginning to collect data on whether, if you knew your genetic makeup and what you might be prone to, that might save the system if you were to take preventative measures or in the use of preventative medicine? Has any thought been given to that?
Sure. I think that this is where we are research-wise. There's a lot of research funding and research initiative right now because we're at the translational stage of most genetic research and of personalized medicine. So right now we're coming up with models demonstrating that, yes, it would be cost efficient to actually proceed with the new genomic medicine. One of the issue with that is sometimes it's not because you have the power to detect your future chance of developing a disease that you're actually going to take that opportunity. Some people might take that opportunity, some people may not. And again, some people who might have taken the opportunity might decide they won't do it because they're afraid of potential risk of genetic discrimination. And that's very true and gets back to our issue here.
Well, to follow up on that.
If I could just add to that briefly, I don't disagree. I think that it's important to point out, though, that the whole genome technologies that we're discussing are already saving the healthcare system an enormous amount of money because they are able to diagnose rare genetic disease where we would have spent hundreds of thousands of dollars trying to find that diagnosis with our more conventional means. Yeah.
What psychologically have you looked? What kind of psychological impact does it have on somebody? I go to my family doctor, he draws up my genetic thing, just like in my folder, the list of shots, and he said, all right, you're going to be prone to Alzheimer's, you're going to have this, you're going to have that. Is that helpful? I guess I'm just wondering how much knowledge is too much knowledge.
Well, I'll put a little plug in for genetic counselors in that case. That is the key role that we play is to really help the patients understand the implications of their genetic test result and tease out, again, the psychological aspects. Are you ready to get these results? How is this going to be beneficial to you? So, that is a key component. That is some concern that people may try to get anonymous testing so that their insurance company doesn't find out about it, and by doing that are circumventing the usual process and not having access to genetic counselors and that service to help them deal with preparing for the results and interpreting and dealing with positive test results.
Well, you've brought up an interesting question. Should we all be able to be genetically tested?
Well, I mean, right now, through some genetic services, it is possible to get genetic testing without there being
a reason,
anything in your family history. For example, if you do 23andMe, it is possible to get some data about modified health risks from that. And my concern is these could be useful to know if you do have a higher risk for diabetes or for thromboembolism, because there may be some things you can do. But because the scientific evidence is not, as strong yet, because there's still a lot to learn in that area, you wouldn't want people to be discriminating for you based on that information. You could send that same blood sample to 2 different companies and get different risk calculations. So again, the validity of some of the tests, there's a question about that. And so, what's to stop the insurance companies or employers asking for that in advance, even though the scientific validity isn't there yet?
Okay.
Thank you.
If I might address, 23andMe does not provide a risk calculator with regards to the results. The modified product that was launched in September includes a much smaller subset of health risk and only identifies that the gene is associated with the health risk, so it doesn't provide any kind of a risk calculator. And genetic counseling is offered to consumers as part of the service. They have to elect to do that, but it is available to them. And as to the point of what studies have been done with regards to the psychological impact of testing, I'm not aware of studies in Canada, but there have been several researchers in the U.S., including Professor Robert Green at Harvard and Professor Uta Franca, who have looked at the psychological impact of the genetic information on patients and have not found any long-term risks associated with that. And I'd be happy to share copies of those papers with the committee members or anyone else who might be interested in it.
I do want to clarify. I have a 23andMe test report that has the health risk assessment on it.
Yes, but do you have it? It's prior to September.
Possibly.
Yes, yes. So you have an older one. Yes.
Thank you very much, Madam Chair. Following up on Senator Eaton's to some extent, the information, and since we have 2 councillors here, we have Ms. Rutberg and Ms. Gibbons, you're relating some very complex scientific information to your patients that perhaps the average patient would not be able to understand. I'm wondering then, if you're trying to relate the most up-to-date information, what is your communication between the scientists who are working on the situation and you're getting that information, and how is that go forward?
I think we work genetic counselors as a team with the health care professionals, and we act as almost an intermediary between the laboratory scientists and the patient trying to explain the information. So we're often on the front lines and people asking us, do I want to have this test? What's the pros and the cons? And there may be difficult decisions to be made. We constantly have to update ourselves about that information. But it is very common in our field, as you've heard, that patients have the fear. And we often state to the patient that that fear is certainly higher than the actual number of cases of known discrimination. But that fear can be enough that someone will be cautious or actually turn down a genetic test. And they're making an informed decision, I believe, in the most part.
Does the patient decide against genetic testing on a regular basis, or is it something that has come out from the counseling? Perhaps you've been able to highlight some of the different issues that may be involved for that particular patient at that time. Just wondering, how often would a person sort of decide against the testing after counseling?
As Dr. Graham stated, it's on a very regular basis, especially for young people who are just starting their careers, might not have life insurance in place. They're not sure whether they want this information for their own health risks and management in the future, but they are very concerned about the risk of the insurance denials in the future. So I tell people, go get your insurance when you're young and healthy, and then come back and see me after you have that insurance in place already, and we can discuss the other aspects of getting the genetic information.
Yeah, I would agree. It's a daily occurrence. This morning I had a clinic. I saw 3 patients an hour each, and 2 of the 3 patients I had the insurance discussion with them. The other one, it didn't apply. And of those 2 patients, one of them chose not to have genetic testing because of their fear that their 4-year-old son would never be able to get insurance as an adult.
Thank you. No? I had questions of Mr. Joly. You know, if I'm not mistaken, in the literature review that you published in 2013 as Genetic Discrimination in Life Insurance, it was your paper, is that correct?
That's correct.
And you did a systemic review of the evidence, and the abstract at the top of the article summarized your conclusion, if I may. It said important methodological limitations and inconsistencies among the studies considered make it extremely difficult at the moment to justify policy action taken on the basis of evidence alone. This is what you wrote. I've noticed that several countries included in your literature review have already adopted laws prohibiting insurers access to genetic information. And so it struck me as strange, and I would like to think that it's unlikely to find much evidence of genetic discrimination among insurers in countries where they are prohibited from accessing genetic information. Can you comment on that, please?
Well, so again, there's the fear and the actual case of discrimination, and I think that what happened is that a lot of people actually in some countries, like for example, we talked a lot about GINA in the U.S., and even though I'd like to believe it's a great solution, the fact of the matter is it doesn't apply to life insurance, and that very few U.S. states have actually adopted law after that. To address life insurance. There are a few, but they're a minimum number. And so what happened is that people can still be discriminated against, and a lot of people are not even aware that the protection exists or that they can have access to it. And therefore, the fact that there's been protection or not didn't really influence the result of the studies in the different countries. And I mean, if you want to know where people are actually the more worried in the world about genetic discrimination and access to, for example, insurance, it's Europe. And Europe is the part of the world where the most of the legislation was enacted. People are still worried.
Why? Do you know why? What is your experience? Why are they worried?
Because I think there are still enough loophole in the existing protection that people want an even greater degree of protection or don't feel that's enough.
And one of the things you said that was interesting is that the insurance company, in places where there's legislation, if I understood you correctly, is that they will not say no, but they'll get back to you, and it'll take forever. And that was an interesting thing
yes.
you said. And
there's an Australian study that has really looked at some of these things and actually studied the way the insurance market was actually using genetic result and if they were applying the policies that were in place. And they did find these sorts of loophole where insurers would actually not completely, would try to circumvent policies one way or another, and it did happen. It didn't happen on a large scale, but it did happen on few cases, absolutely. So there are ways to do that, yes.
I'd like to ask a question of the rest of the panelists, and that is, if this bill has not passed and the status quo is maintained, what will be the impact to your clients and generally to Canadians?
I do think fewer people in Canada will certainly access our service out of a concern that the information could be misused.
And in genetic counseling, I think we will continue to see people decline getting genetic testing for fear of genetic discrimination.
We will also continue to hear stories where insurance companies have misinterpreted the information and wrongly discriminated, which makes us very frustrated that someone who doesn't have a medical background is making such a decision that could have an important financial toll on a family and individual.
Dr. Graham, do you want to comment on it?
I agree. Those are my concerns as well. I agree with all 3 comments. My other concern is that the absence of a genetic test because of a fear of insurance discrimination will prevent some individuals from going forward with surveillance, medical surveillance opportunities that could reduce the morbidity of their genetic disease.
I want to thank all of you. I also want to apologize to you to keep you waiting. And I want to thank you for your presentation. And when you return and on reflection you think there was something we did not cover, if I may please again impose on you and say, could you provide us that information in writing, because we're still studying the bill and we look forward to working with you in the future as well. Thank you very much.